Well, now that Chille has lost on his 2 counts and is in jail, let me address what I think is going to happen with this appeal, because I think he will appeal. First of all, he's dead wrong if he thinks the appeal will be decided within the next 6 months. No way. It's not a high priority case. It's a misdemeanor case. It's going to probably be a year and a half before it's heard, but he's not getting out in 30 days. No way. Also, they would know that he's a flight risk because of the warrant that's out in Ohio that I'm told is out there. I saw that in a traffic stop. So getting him out on bond would be very difficult. He'd have to pledge collateral and security, especially with a bail bondsman thinking that he's going to abscond. So I think he's staying in jail. Next, what about the appeal itself? A lot of people have a misunderstanding of what happens with appellate process. First of all, he is going to need an appellate lawyer. Appellate law is a completely different animal than regular trial work that I do. Appellate court is going to look at errors in law, errors in admissibility of evidence, testimony that was not supposed to be entered into the record. But before they get to that step, they're also going to be looking at whether or not the person complaining about it did what's called invited error. In other words, did they object on the record to this? If there was this was a very short trial, so the record is pretty small. Let's just talk about what the judge did from an appellate point of view. From an appellate point of view, she said very clearly that she based her conviction on what she saw with the videotape. Now, was it a good idea for Chille to give the thumbs up and agree he hates all cops? She even said, look, he's nodding approvingly here. No, it's never a good idea to antagonize a judge when they're handing down a sentence. In terms of the sentence itself, it's in the midpoint of what she could have offered. So I warned about that, and I also warned that they could string them together consecutively in my other video. You guys have all seen that. I went out and told you what I thought would happen, and it pretty much happened as I told you it would. She strung them together. Well, now, 6 months is a long time. Okay, that shocked me. That was harsher than I was expecting. I mean, the DA wasn't even looking for jail time in a suspended sentence. And the judge looked at the DA like, you got to be kidding me. So did the judge abuse her discretion? No, you're going to lose on that. I'm just telling you, you're going to lose. The judge has wide discretion. Discretion isn't unbridled, as they say. There are limits to discretion. For example, discretion does not allow her to commit an error of law. In California, for example, if you want to file a 170.6 motion to disqualify a judge, you have to do it within, I think, either 10 or 15 days of being served it. The other thing is that Chille's antics in the beginning of the case, calling the marshal a pig, the judge could have held him in criminal contempt. Criminal contempt is any violation that's in front of the judge. But the judge warned him and decided not to. So that's going to be count in her favor when people say she's biased. What I heard was basically the lawyer arguing the defenses that Chille was going to offer, First Amendment defenses. Well, First Amendment defenses, those are pretty touch and go. I don't like those because this is a criminal case, not a civil case. And in a criminal case, you better have case authority like the judge asked for. You better have case authority that supports your position that this is an absolute defense to the charge. It's not easy to do in the criminal arena. And if you say, well, and I saw people writing this, you can't criminalize a constitutional right. Yes, you can. It happens all the time. I'll just give you some obvious examples. You want to yell bomb on an airplane? Good luck. Your First Amendment doesn't cover you in an airplane. Okay? You can't yell fire in a theater. You've heard that cliche because it's true. There are limits to everything. There is no such thing as unlimited constitutional liberty. Believe me, over time, they found ways to shave it down. The constitutional test for you YouTubers out there that want to be lawyers, rational basis. Any rational decision by the government will be good enough to apply it as long as it's applied in a neutral fashion. Next is, there's a mid-level scrutiny and then there's strict scrutiny. Strict scrutiny is anything that would impinge on a constitutional liberty, and it has to be narrowly, there must be a compelling government interest. I didn't hear any cases discussed in the closing argument that would support a First Amendment defense. Now, Michael Mee said that he submitted them to the judge. It is in the record. The appellate court will do its own legal research and analysis on that. And there's the question of the admitted evidence. We only had 2 witnesses, and only the cop was cross-examined. Chille wasn't cross-examined, which really surprised me. I mean, I would have had a lot of fun cross-examining him. But I'll get to that in a second. So the appellate court's going to see, was the evidence competent? Was it admissible? Was it relevant? Was there any objections to it being admitted into evidence? And if not, how prejudicial was it? Would it affect the outcome? Next, there's a lot of other ways that you can admit evidence, even if you failed to object. Maybe there was a mistake and it shouldn't have been admitted, whatever. It doesn't change the fact that the parties that were in that tape were the ones that were narrating what happened. The cop was, yeah, that's me, that's him. Yeah, that's the distance, that's what I said. It's coming in a different way. It's coming in through direct testimony. Anyway, the tape, even though it got admitted, there was enough there, I think, independent of the tape to still convict him. Now, the next issue would be the constitutionality of the statutes themselves. There's an uphill battle here. Trial courts required to uphold the statute because it's been declared constitutional. I've already gone through all of that in another video. If you guys have read and watched my videos, I gave you the cases, in fact, and I analyzed the cases. And the Nevada Supreme Court has declared these statutes constitutional, and they have used officer safety as the primary motivation. So what did the cop do? He talked about officer safety. Now, there's a problem with what he said. He's given an inconsistent statement. He says that officer safety is the reason for the 21-foot rule, but at the same time, he also said he didn't think that Chille was going to threaten him, wasn't a threat to him, and that's why he didn't tag Chille with a more serious battery charge. So officer safety really wasn't the overriding concern here. The next thing is would the appellate court be able to do anything other than punt? These statutes have been declared constitutional even without a minimum restriction on how far back you're supposed to stand from the cops. Now, there is no hard and fast rule, and maybe the Supreme Court doesn't really give a shit and won't even want to entertain that rule because it'll be one of these mixed questions of law and fact, and they just aren't going to give you a hard and fast rule that you got to be at least 10 feet back. Obviously, the farther back you are, the less of a threat you are to the cop. But just by being near the cop, you are a distraction, especially if he's worried about you. And here's what happened. I'm just going off of my instincts as handling this almost 18 years and 34 trials. This standby counsel thing is just an absolute disaster for a lawyer. I would never agree to this. And here's why, because now you're sharing command with the person who doesn't have the training you have. You know, TV is not how law is practiced. I'm telling you that Michael Mee is a fine lawyer. You should see his wins, okay? He's not new to this game. But let me just say it from my perspective. I got a client who thinks he knows everything and thinks he's smarter than me. He's smarter than everybody in the room. And he's not, okay? All right, he's not. Never would I tell a client, okay, you can take over the case and I'll just sit back and watch you. And if you have a question, I'll help you with that. Never. A person who is untrained in that is going to flounder. It looked to me like what happened was Mee was supposed to step down and Chille was supposed to take over the case. But now the judge is coming back saying, no, I'm not going to allow that to happen. Now Mee's first chair again. And now he's off balance because when he thought he was going to be sitting in the background, now he's in the front line. And I think he was very uncomfortable with the whole situation. I don't think that he showed, I mean, when he was crossing his arms, you know, I don't think these are the arguments that he wanted to make, but he has to do what his client wants. So bottom line is that I don't see this appeal working out too well. The deck is stacked. The Supreme Court would probably just simply punt back and say, we've already ruled on the constitutionality of these cases and that's it. And then force Chille to go to the Ninth Circuit. Now, if he goes to the Ninth Circuit first without trying to develop a record in the lower courts and the appellate courts, then he has less of a chance for them to even hear the case because they turn down over 90% of the cases that are given to them anyway. So that's where we're at. I think the convictions are going to stand. He does raise an interesting constitutional question because I do not like the statutes. Well, we'll just have to see, but he will definitely need legal representation for this because these appeals are difficult.